All right, so we now discuss the Salomon case. This is Salomon versus A. Salomon and Company. So this is Salomon the individual versus Salomon and Company, the corporation. So this is probably the single most important case in corporate law, reaffirming the doctrine of the separate legal entity of the corporation and refusing to lift the corporate veil. And so the corporate veil is a concept that we apply because the company is treated as under the company's law legislation in most countries now, the company is treated as a separate legal entity. And so we say that there is a corporate veil between the company itself as a separate legal entity, a artificial person, but nevertheless a legal person, and the shareholders of the company or the members of the company who are natural persons and also legal persons. So ordinarily what the Salomon case is actually well known for reaffirming is that if there is no fraud or irregularity that can be proved with respect to the formation of the company, then the default presumption of the court will be that the veil is not going to be lifted, and the burden is on the person who is agitating for the veil to be lifted to show that there was some kind of illegality in the formation of the company, or there are some other valid judicial reasons or statutory reasons for lifting the corporate veil. Right, the first thing to note about the judgment that was given to you is a slightly redacted version of the judgment. There is another, I've given you a link for a longer version of the judgment, and we are going to refer to that longer version to understand some of the I've extracted sections from the longer version of the judgment. But anyway, the essence of the case can be understood even from the redacted version. The first thing to note about this case is, before we even get into the actual legal principles, the first thing to note is how complex the procedural posture of this case is. Procedural posture is a new term that you're learning. It relates to slightly technical aspects of what is the actual history of the case as it is traveled to the court whose judgment you're now reading. And it also includes the idea of the particular issues that are before the current court. So, I mean, for instance, if you remember in Hadley versus Baxendale, although it is known for establishing important rules with respect to when special damages can be claimed in a breach of contract case, the technical question that the court in Hadley versus Baxendale was required to decide was actually whether the instructions to the jury were properly given, and whether therefore there was, because they were not properly given, there was a need for a new trial in the case in the court below. And that's the specific issue on which the higher court ruled. So that's the idea of, so although you don't need to really understand the procedural posture very well in order to extract the ratio decidendi of the case and then argue in court, be able to distinguish cases, but it's good practice to be able to understand, to train yourself to understand the procedural posture, because it just leads to it just fosters more rigor in analyzing cases. So here what's happening is that, well, let's just quickly run through the facts of the case. What is happening is, what I've got here is actually the final parts of the case. What happens, so you have this leather merchant, Salomon, who is running his business, and then eventually decides to take advantage of limited liability provisions of a company under the UK Companies Act. And then through two transactions, he sets up a trustee to set up the company, and then eventually sells the business to the company, which is now called Aaron Salomon and Company. Now, so through these two transactions, so now eventually you have a sale of the business to the company. Now Aaron Salomon remains the majority shareholder of the company. So you can see here that the nominal capital was £40,000 and 20,007 shares were issued. The appellant holding 20,001, and the rest being held by his wife and sons and daughters. So all being held within the nuclear family. So now what happens is, after this, there is he issues, this is important from a procedural point of view, because Salomon is paid partly in debentures, in £10,000 of debentures, This is the consideration for the sale of the business to the company, and the company is paying Solomon by issuing him 10,000 pounds of debentures. What Solomon does with these debentures is he uses them as collateral to take a loan from one Edmund Brodripp, and he takes a loan of 5,000 pounds. And so 10,000 is the 10,000 pounds of debentures as security for this loan of 5,000 pounds. And eventually what happens is that there is there's a succession of strikes in the boot trade, and the business gets into trouble, and eventually Mr. Brodripp finds that his loans are not being paid. He tries to enforce the debenture, and that's why he sues the company. And then there's a liquidation action brought by the unsecured creditors. So eventually, because of the company getting into financial distress, they are being sued by their creditors, both secured and unsecured, and then you have liquidation proceedings. And so what Mr. Brodripp's action is being contested by the liquidator of the company. But what happens is, why I'm saying the procedural posture is very complex, is because while the liquidator is answering the charge, he's defending against the claim made by Mr. Brodripp. He's also launching a counterclaim against Mr. Salomon, the individual, and asking him to indemnify the company for the payments to the unsecured creditors. As you can see what is happening here, this is the part that I've extracted from the judgment. As a result of this financial distress, what is happening is we realize that the assets of the company are insufficient to pay all the creditors. Forget about paying anything to the shareholders. They're completely wiped out. So if you take the assets of the company, you sell the assets, and you pay off Mr. Brodripp for principal and interest, then you have a balance of about 1,000 pounds, which obviously the applicant in this case, which is Mr. Salomon, he's claiming that 1,000 pounds because he's a secured creditor, because remember that he's the beneficial owners of the debentures which he had mortgaged to Mr. Brodripp. So now if the company pays the 1,000 pounds to Mr. Salomon, as in his capacity as the beneficial owner of the debentures, then they would have nothing to pay to the unsecured creditors who are owed slightly over 7,000 pounds. So this is the problem that we have, and this is why the liquidator of the company is launching a counterclaim against Mr. Salomon and saying that, as you can see here, in name of the company to the debenture suit, this is the suit that is filed by Mr. Brodripp, and he's counterclaiming against the appellant, which is basically Mr. Salomon, the individual, to have the agreements. These are the two agreements through which the company was formed and the sale of the company was made. The sale of the shoe business was, the leather business was effected to the company, and essentially asking for Mr. Salomon. So what happens then is that the trial court does not allow this particular counterclaim, but then requests the liquidator to amend the counterclaim, and then he allows the amended counterclaim. So essentially he rules against, the net result is that he rules against Mr. Salomon and holds Mr. Salomon liable to pay the unsecured creditors up to this amount. This is the problem. This is why Mr. Salomon is now coming to the court. He went on to the Court of Appeal, Mr. Salomon, but even there he was thwarted. So the Court of Appeal ruled against Mr. Salomon. But since the Court of Appeal also did not award the original claim of the liquidator, the liquidator also comes up in cross appeal to the eventually to the House of Lords. If you can see here, this is the trial before Vaughan Williams in the trial court. Then you have the Court of Appeal. Okay, here. So you finally see, as it comes to the House of Lords after the Court of Appeal, the appellant is obviously appealing because he's been thwarted by the Court of Appeal, and the company brought a cross appeal against because there was the original counterclaim which the Court of Appeal and the trial court had not awarded or had not allowed. So this is why I say that this is a very complex, this case is a very complex procedural posture, and it's a good habit to try and understand this complex procedural posture just for developing the practice of bringing analytical rigor to the study of a case. So you have this is called a cross appeal, when the appellant, that is Aaron Solomon, is appealing to the House of Lords against the judgment in favor of the company's liquidator. But the company's liquidator is also unhappy with part of the judgment in the court below. So he brings another appeal. This is called he's also appealing against the judgment of the court below. So this part is called a cross appeal. So it's very complex with counterclaims, debenture suit, a counterclaim, then cross appeals, etc. So anyway, this is where we find ourselves, where the House of Lords is now adjudicating on this matter. Primarily, they are adjudicating on the question of whether Mr. Salomon is to be held liable for paying the unsecured creditors. This is the question that was asked to you for your case presentations. Why should Mr. Salomon not be held liable? Because we know what the court did. It didn't hold him liable. So what is the logic that the court used in coming to this conclusion? So one more thing to note is in terms of procedural posture, because remember the shareholders have been wiped out, so Mr. Salomon is in great financial distress. So he's actually filing this suit in what is called informa pauperis, as if he's actually a pauper. He's filing this case as a pauper, and that's also going to affect when the House of Lords finally rules in his favor and awards costs. That is also going to affect the costs that are being awarded because he filed this case as a pauper. So now, anyway, so the short answer to why Mr. Salomon should not be held liable is that if the company has been properly formed under the terms of the Companies Act, it is a separate entity, and nobody has been able to show proof of fraud in the incorporation of the company or in the sale of the business to the company. And so the short answer is that since the company, being thus properly formed as a separate entity, the debts that the unsecured creditors have, the money that they have advanced and the debt that the company owes to the unsecured creditors are the debts of the company, not of Mr. Salomon the individual, because the company is a separate legal entity. So therefore, and then the unsecured creditors obviously knew that they were dealing with the company. They were not dealing with the individual. And this is something that is not mentioned by the court, but can be brought up in argument in a similar situation. And that is that the unsecured creditors were not dealing with the company for the sake of doing charity. When they were acting as vendors to the company, they obviously had certain profit margins built into their prices. So they were looking to make a profit by dealing with the company. And they knew that the debts were the debts of the company. So now they cannot be they can't really just come to the court and say that, oh, we were just cheated out of our money. They were actually looking to make a profit through a normal business transaction, which is not a crime, but it's not like they were just taken for a ride by the company. So this is essentially the short answer to this question. Now, the importance of this case lies in the fact that even though the Companies Act had been put into place a few years earlier, it's amazing how the lower courts have because this was a new concept in England, so the lower courts were not willing to really strictly enforce the idea of the sanctity of the corporate veil and not lift it willy-nilly. So they were actually, as you saw in the case in the trial before Vaughan Williams and in the Court of Appeal, where very well-known justices like Lord Lindley were also prone to, looking at all kinds of fuzzy reasons why Mr. Salomon should be held liable. And they failed to apply a formalistic approach and look at the strict wording of the statute. So they failed to be textualists in the lower courts. But as you can see, the House of Lords is actually giving you a very good example of textualist ruling in this particular case. So we'll come back to the details of the House of Lords and when we discuss the third part of the question. The second question was, is the corporate veil lifted or not in this case? Obviously not, and again, because there was no proof of fraud in the incorporation of the sale of the company. You will see later on in Lord Watson's judgment, Lord Watson's opinion, there is a reference to this case called Elanger versus New Sombrero Phosphate Company. And you will see that that Lord Watson actually here, Lord Watson's judgment opinion here, lots of a good recitation of the facts of the case. Alright, towards the end of his judgment, that as given to you in the redacted version. So there was the counsel for the liquidator tried to apply the precedent of Erlanger versus New Sombrero Phosphate Company, which is a case where there was actually fraud, and the transaction was set aside. That is, the sale of the company was set aside, and they wanted the same thing to be done in the Salomon case, but Lord Watson shoots this down. Essentially, he engages in what? Because he says that in that particular case there was fraud, a fraud perpetrated on the shareholders of the company by Erlanger. So that case is to be factually distinguished from the current Salomon case, because in the Salomon case there is no proof of fraud in the incorporation or the sale of the company, because the shareholders bought the company with full knowledge of what they were buying, and in fact the business was quite healthy when the company bought the business. It's just that later on, financial distress, a situation of financial distress developed because of the strikes in the boot trade. So what Lord Watson does here, remember, just to recap your learning on distinguishing, this is a case of non-restrictive distinguishing, that is, distinguishing based on facts. So Erlanger versus New Sombrero Phosphate Company, as the judge says, has no application. It is non-restrictively distinguished from the Salomon case. So that's another reason why the corporate veil is not lifted. Now the third question that was asked to you, where we'll see we have the longest answer, and is really the major learning from this case, in terms of the style and the judicial philosophy and the application of a judicial philosophy. Does this judgment exemplify formalism or realism? Okay, look at this here. It just said this is just apart from the judgment. Everything here is an extract from the judgment, the longer version of the judgment, which I've hyperlinked to above. So you have the memorandum. Okay, so this is the company's constitutional documents are submitted to the registrar. The company has gone through all the formalities of the process as outlined by the legislature, and the effect of registration, if otherwise valid, was to incorporate the company under the name of Aaron Salomon and Company with limited liability limited by shares. Okay, so essentially now you have the birth of the company when it is incorporated according to the provisions of the law, and from this moment on the company is a separate entity, the power to be sued, to sue and to be sued in its own name, to acquire, hold, dispose of property, etc. So now it is distinct. It's a distinct entity from the shareholders. Okay, so here I'm just extracting material to show you why this judgment is. This is almost like this would be the first chapter of the Bible of legal formalism. The judgment in this particular case, essentially, as I'm saying, is like the first chapter of the Bible of legal formalism. It's a wonderful testament to how the House of Lords exposes the flawed and fluffy reasoning of the lower courts, and essentially applies legal formalism in a very beautiful and consistent manner. Okay, so Vaughan Williams apparently thought that the company was the agent of the appellant, but there's no evidence. Okay, the sale of the business is bona fide. This is important. All the requirements of the Companies Act were strictly complied with. Classical example of formalistic reasoning. Whatever the Act says needs to be done was done. So why should we find fault with this situation? Now, the judges below in the courts below did not like the fact that Solomon used the company to convert his unlimited liability to a limited liability, but that's the prime object of turning a private business into a limited company, and this has been sanctioned by the legislature through the Companies Act. So what's the problem? So this is where you see how sloppy the reasoning of the court below was, of the two courts below was, and how judges allowed their moral proclivities to interfere with their assessment of the legalities of what was before them, and they failed to apply legal formalism, which the House of Lords does very well. Okay, so they've cited certain sections of the Companies Act. No problem with the objects. Okay. So court cannot impose conditions not imposed by the legislature. This is a general statement, again, of a formalistic philosophy. And the courts below were saying the shareholders should be independent. But there's no such thing in the statute. There's no requirement in the statute. Okay, so there's no requirement that they should be independent. So therefore, there's no problem with what was done. Okay, so here you have Lord Halsbury's opinion, and I just want to go back here a little bit to this. If you remember when we discussed. I'm trying to figure out where we had the discussion of FILAC. I think it is in the Feldhaus case. Yeah. Okay. Many of you said that this is when we discussed the two frameworks that we typically use for case analysis. The IRAC framework in the U.S. law schools. And the FILAC framework in the Australian law schools, and I've actually tampered with the US framework a little bit to make it symmetrical. I've added the facts as a F in brackets because the actual framework is IRAC, but I've added FIRAC. I've added an F and made it FIRAC, and so that it corresponds to the Australian framework. And the only difference is here L stands for legal principles and R stands for rules, but they both refer to the same idea. That is, what is the law? What are the legal provisions that apply to this situation? Any statutory provisions, any constitutional provisions, any legal judicial precedents, any juristic works, like you saw a reference to Cheshire and Freefoot in the tendering case, Cheshire and Freefoot on the law of contracts. All of these would qualify as legal principles or rules. So many of you said, now the reason I'm referring to this framework at this stage of the discussion is on the question of whether this is a judgment, this judgment of the House of Lords exemplifies formalism or realism. Many of you talked about, many of you got the answer right. You said this is legal formalism, but you said that this is legal formalism because the judgment is given based on the facts of the case. That's not correct. Every judgment has to be given based on the facts of the case. The real difference between formalism and realism lies in, if I now were to put a couple of columns, what's on top? Okay, if I were to put a couple of columns here, all right, maybe just drag it here. So it is only at this stage. So you have facts, you have issues, you have legal principles or rules, you have the application of legal principles, and you have the conclusion. So it is only at this stage that you have the question of formalism or realism. So here you have the question. Okay. So it's not a question of it's formal. I mean, it's not correct to say that it's a legal formalism because the judgment is given based on the facts of the case. That's not where the difference between formalism and realism comes out. The stage of the case analysis where it comes out is the application phase, where you state the legal principles and then you apply the legal principles. In a formalistic judgment, as you see here in the House of Lords on the Salomon case, they take a very textual approach, whereas in the case of legal realism, you could actually say that the courts below have tried to, their approach is probably best characterized as a kind of a sloppy form of legal realism, because they tried to look at the purpose of the statute. But they, if you notice here, the judge himself says here. In order to determine the question, I have no right. All of these are wonderful statements of the formalistic philosophy, the parts that I've just underlined. So statute says nothing. And if you see here, as I was saying, that the judges below have adopted some kind of a sloppy legal realism approach, because they've tended to look at the intention of the statute. Remember? Here the judge is quoting one of the judges in the court below. The object of the whole arrangement was to do the very thing which the legislature intended not to be done. And then Lord Holsbury says, it is obvious to inquire where is that intention of the legislature manifested in the statute. Okay, that if the legislature intended to prohibit something, you ought to know what that something is. So this is again example where he's criticizing the way that the judges in the courts below have tried to apply their understanding of the intent of the statute without really taking a textualist approach, and they've kind of assumed that there was somehow the intent of the statute is being sort of defeated. So all of these are examples that all of these show you why this is a judgment that exemplifies legal formalism on the part of the House of Lords. Okay, so now that we've covered the purely legal aspects of this case, now we'll go on to what we, in our phase 2 typically of the discussions, we'll go on to any incidental learnings we can pick up from this case in the realm of finance. Okay, so the first thing we can learn is actually the idea of a haircut. What can we find in this case? Where are the points of departure in this case where we can learn about so I'm going to use GBP for pounds, and okay, so the first term we're going to learn, a finance related term that we're going to learn by using a point of departure that occurs in the case, is the idea of the haircut. The idea of the haircut is this is an expression that appears in secured lending situations. And what it means is, let's refer to the facts of the case. What did Mr. Brodripp, how much money did Mr. Brodripp lend to Mr. Solomon? £5,000. And what was the value of the security that he took from Mr. Solomon? It was £10,000, because the debentures, the face value of the debentures was £10,000. So here, so let's write this, the concept of the haircut, it appears in secured lending situations. Okay, I'm just not going to write situations. So secured lending situations. So secured lending is anywhere where the loan is secured, that is, the interests of the creditor are protected by the borrower parting with some kind of security, either movable or immovable property, which the creditor can sort of enforce his interest against if there is a default in the payment of the loan. So what is a haircut? So here in this situation, you have a £5,000 loan with 10,000 pounds of collateral value. So here we say that the haircut is, here we say that the haircut is equal to £5,000. Essentially the haircut is nothing but, the haircut is £5,000. So the haircut is nothing but the value of the collateral minus the value of the loan. You've seen this, you're already familiar with this phenomenon, when you know that if you look at housing loans, if the value of your house is say 100 million rupees and you go to the bank for a housing loan, they're not going to give you a loan of 100 million rupees. They will give you a loan maybe of 75 million rupees or 80 million rupees. So that 20 million rupees, if they'll give you a loan of 80 million rupees against a house that's worth 100 million rupees, what they're doing is they're applying a 20% haircut to the value of the collateral, or you can talk about the haircut in absolute terms as 20 million rupees. So that's the first term that we learned. Okay. Now, another thing we can learn in this particular case, okay, there is, you notice here that it says when the company was incorporated, limited liability, limited by shares, nominal capital of 40,000 pounds. Okay, and okay, so what does nominal capital mean? Nominal capital is what we refer to today as authorized share capital. It's maximum equity capital the company is allowed to raise through the sale of its shares. Okay, so there are certain other terms that you want to learn in relation to in relation to the authorized share capital. The other concepts that you can learn is the idea of subscribed share capital, issued, and paid up. Subscribed is the amount that the shareholders commit to the company to be liable for. Then when it is issued to them, that is called the issued share capital, the amount of shares that the company is actually issued to shareholders. So obviously issued will be less than equal to subscribed at all times. And then paid up. So once you have subscribed is different from paid up, because subscribed means you're just showing your intention to be liable for this amount, and then paid up is when you've actually paid up that contribution to the company. So if you see the Salomon case as well, this is after the formation of the company that Salomon applies for the shares. Okay, so he subscribes for the shares, and then the shares are issued and paid up. So subscribed share capital, issued share capital, paid up share capital. And what we mean when we talk about a corporation being a limited liability company, what we really mean in particular is that the liability of the equity shareholders or the common shareholders is limited to the amount of shares subscribed to but not paid up, because we assume that that if you've already paid in the contribution for your shares, that amount is not really taken as part of your liability because you've already paid that capital into the company. So your liability is limited to the amount that is subscribed to but not paid up. That's what we mean typically when we say that the liability of the shareholders is limited. Okay, so another thing that we're going to do in this case is we're going to quickly just do a balance sheet concept check, just to make sure that your understanding of accounting is good. So very basic stylized balance sheet from a finance perspective. Let's look at this first concept check. So you have a company with 5,500 pounds of assets. Okay, so this is, let's say this is a car dealership, or it's a car company, let's say, that just manufacture cars, and they've got this current assets, this is inventories, 50 cars, each car is worth 100 pounds, so the value of inventories is 5,000. You have factory worth 500 pounds. These are not realistic numbers, these are just some numbers I've plugged in. And on the liability side, we have, this is again a finance perspective on the balance sheet, so we call this, we say owner's equity, sometimes called net worth. Okay, also known as share capital and reserves. This is the term that we use in India, share capital and reserves. Internationally, we say net worth or owner's equity. And then you have outside liabilities on the other side, on the liability side. So this is essentially all the capital that is in the form of debt. And so outside liabilities, strictly speaking, the term should be liabilities to the outsiders. Okay, but we just call it outside liabilities because from a finance perspective, the owners are kind of treated as insiders, and then you have the liabilities to outsiders, people who are not the owners of the company. We say owner's equity. Remember, in finance, we refer to the shareholders as the owners of the company, but strictly speaking, from a legal perspective, we don't like to say owners of the company because no one owns the company. It's a separate legal entity. We say shareholders, equity shareholders or common shareholders. They own the shares of the company. They have voting rights, and therefore they can appoint the management team. and therefore they are able to exercise control over how the assets of the company are going to be utilized in the conduct of the business of the company. But they're not really, strictly speaking, the owners of the company in a legal sense. But nevertheless, we're studying this from a finance perspective now, so we'll say owner's equity because it's a very common term in finance. So the point to understand here is that net worth is a residual. This is the important learning in this particular sub-module. Okay, so we say that net worth is a residual that you have to understand, which is, maybe we just incorporate this here. We say net worth is a residual. Okay, residual means whatever's left over. So what does that mean? What that means is essentially, see, now you have this balance sheet which has 2,500 pounds, 2,500 pounds of owner's equity, 3,000 pounds of debt, and you have these outside. Now suppose there's a problem in the car trade, and you have a accountant comes and says that no, your inventory is not, it needs to be revalued, it needs to be marked down, so the price of each car is not 100 pounds anymore. The price of each car is, notice what is the level of debt. You have 3,000 pounds of debt. That's the face value of your debt. So now the accountant says that we can't value the cars at 100 pounds each. We have to value them at, let's say, 70 pounds each. Okay. Notice what happens. The value of the total assets goes down to 4,000 pounds. But is there any change in the outside liabilities? No. You can't change the face value of your debt just because the value of your inventory is now gone down. So the entire weight of market forces, of the impact of market forces on the value of your inventory, the negative impact falls on the owner's equity. Remember, it was about 2,500 pounds. Now it's gone down to 1,000 pounds. So the owners have lost this money. The shareholders have lost this money. So that's what meant by, this is also net worth. So this is your net worth is a residual, because it is what is left over after subtracting the outside liabilities from the total assets. So you value the assets, and the value of the assets can keep changing depending on market conditions. And so you subtract the debt, that is the outside liabilities, from the total assets, and what's left over is the owner's equity. And so if you have a situation like what actually happened in the Salomon case, where the value of the cars is, in this case, that was the value of the shoe material, and the value of the shoe business, or the leather business. Let's say the value of the car business, the car business is in such dire straits that the value of each car has fallen to 25 pounds. Let's see what happens. So the shareholders are completely wiped out. So what's going to happen is, since, look at what is happening here, this is what happened in the Salomon case. You have the total assets are worth 1,750, but you have debt worth 3,000. So what's going to happen is some of these creditors are not going to get paid, which is what happened in the Salomon case. So this is your balance sheet concept check, and very related idea is when you look at the two types of capital, and we look at the related idea of what is called the hierarchy of claims. It's an important concept in finance. You go back to the spreadsheet. So if you look at the liability side here, we can sort of write this in greater detail over here. Okay, so we look at two broad types of capital. We have debt and equity. And within debt, you have senior debt, okay, which is usually secured. Okay, but we'll come to the difference between seniority and the collateralization of debt. And so you have senior debt, you have subordinated debt. Sometimes it's called mezzanine financing because it's so deeply subordinated. It's kind of like debt between debt and equity. Okay, so, and then you have equity. On the equity side, you have preferred stock, which is also part of mezzanine financing strictly, and then you have common stock, which is your equity share capital. Okay, so these are the two broad. So we say there are two broad forms of capital, debt and equity, but actually there is a third category which exists, which is a hybrid capital, which is neither debt nor equity, and preferred stock falls within this. Even deeply subordinated debt, for instance, one type of bond that is being allowed in Europe, for instance, now is the CoCo bonds. These are called contingent convertible securities. Okay, so Deutsche Bank has issued some of these bonds. So you can see from these are actually hybrid securities. So they're issued as debt, but in case there is a kind of a trigger event, which is essentially some sort of financial distress, you have a loss absorption. Sometimes there's a complete write-down, so that the principal disappears. Okay, either it converts to equity. So these are hybrid securities. One example is these CoCo bonds. contingent convertibles. So, or preference shares. These are technically hybrid securities, but in the world of finance, if you look at the investment banks and their capital market, their primary capital markets operations, you don't have a division dealing with hybrid securities. You have debt capital markets and you have equity capital markets. These are the two divisions within a primary capital markets operation of an investment bank. So, and typically what would happen is the preferred share issues will be handled by the equity capital markets team, and COCO bond issues will be handled by the debt capital markets part of the team. But for conceptual clarity, it's important to understand that although we loosely talk about only two types of capital, debt and equity, strictly speaking, there is actually a third category which sits between debt and equity, and sometimes is referred to as mezzanine financing. And those are hybrid securities like preferred stock and COCO bonds, other kinds of deeply subordinated debt. So these are the three types of capital securities that you should be aware of. And I included a link to the Goldman Sachs guide to capital markets, but unfortunately this guide doesn't work anymore. Anyway, so hopefully one day it'll start working magically once again. One more thing we can learn from this particular case is on the topic of debentures. If you notice in this case, there's a discussion of debentures. Solomon is a beneficial owner of the debentures. That's why he's claiming the residual amount of £1,000. And so one of the questions, that debentures obviously are a type of debt. Okay. Now the question is, what is this topic is actually outside debentures. It's a separate topic. Let me just take this outside debentures. Okay. Or we can keep it there. It's a subtopic within debentures. Now, as I said, when we looked at this part here, the liabilities, this is called the hierarchy of claims. This whole arrangement, this ladder arrangement, is called the hierarchy of claims. So when the company's hierarchy of claims on the revenues of a company. So when a company is earning money in the course of its operation, the first claim to the money is laid by the senior debt holders. Okay. Then you have the subordinated debt holders. Essentially, we are just skipping over the hybrid part because that includes that. Then you have the preferred stockholders, which is again part of hybrid capital. And the last in line to claim, to lay a claim to the revenues of the company are the common stockholders. And that's why you see that essentially we say that net worth is a residual on the balance sheet front, because the shareholders, the common shareholder, the equity shareholders are actually last in line to lay a claim to the revenues of the company. So this is something else to understand. So technical terms that you should learn in finance, like net worth as a residual, then the concept of the hierarchy of claims. This is just referring to this kind of a ladder structure where the revenues of the company are being claimed by people, by different types of capital providers in a particular, according to a particular hierarchy. So that's what is called the hierarchy of claims. Now within that you see obviously debt, and one type of debt is a debenture. And before we get into the discussion of debentures, one thing we want to clarify is there are two concepts that we are discussing here. One is the seniority of debt, okay, and the other is whether the debt is secured or not. So we can refer to this as the idea of the collateralization. We'll just highlight secured. Whether a debt is secured or unsecured. Remember that in the Salomon case, Solomon is a secured debt holder because he holds a debenture, which in the UK is a form of secured debt. And then you have the unsecured creditors who are actually whose debt is not secured by a charge on any assets. Okay, so this is the difference. So there is a difference between the debt can be either senior or junior. Okay, so debt which is inferior to the senior would be called junior debt or subordinated debt. And then you have debt which the debt may be either secured by a charge on assets or not secured. In this case we say another way to refer to it is to say collateralized. Okay, so the point I'm trying to make here is that there is a difference conceptually between the seniority of debt and the collateralization of debt. It is not necessary that just because debt is senior, it is necessarily collateralized. Likewise, it is not necessary that just because debt is subordinated to some senior category of debt, that it is not collateralized. So for instance, if you look at the global financial crisis of 2008, where you had all these mortgage-backed securities, So all you had different tranches of seniority within those securities, but all of them were actually secured by the same pool of mortgages. So they were all collateralized, they were all secured debt, but there was a senior junior hierarchy which ensured that some people got paid earlier than others. So the point to understand is that don't confuse seniority with collateralization. The two need not always go together. Okay, so this could be topic 1A. Okay, now the other point that I want to discuss with debentures. Now what the question is whether debentures are secured debt or unsecured debt. This is the question that might arise, okay, since debentures are a form of debt. Now the answer to this is that the answer is not clear-cut because it depends on which jurisdiction you're talking about. Okay, jurisdiction is typically a different legal system. Each legal system is a different jurisdiction. So, for instance, in the UK, debentures are, secured debt. As you saw in the Salomon case, Salomon owned debentures and they were secured. He was a secured creditor. Okay, that's why. And then Mr. Brodripp was also a secured creditor with respect to Mr. Salomon because he was holding the debentures as security. So now the debentures are actually secured debt in the UK, but in the US, debentures are actually, this is a term that is used to refer to unsecured debt. So you can see a complete opposite situation compared to the UK. In the US, the debentures are not secured, okay, are unsecured debt. And what's the situation in India? If you look at the Companies Act of 2013, Section 2, subsection 30, it says debenture includes debenture stock, bonds. Debenture stock is just a whole bunch of debentures. No qualitative difference, and bonds or any other instruments of a company evidencing a debt, whether constituting a charge on the assets of the company or not. What does this mean? This means that debentures in India could refer to either secured debt or to unsecured debt. So this is very different again from the situation in the US and the EU situation. In the US, debentures will always be used to refer to unsecured debt. In the UK, debentures will always be used to refer to secured debt. In India, debentures could be either secured or unsecured. Okay, it depends on the situation. The law allows for either situation. Okay, so I've given you an optional topic also to learn. I'm not going to discuss this here. You can just click this link and learn it. It's about fixed and floating charges. To understand fixed and floating charges, very important for those of you planning to go into corporate banking. Okay, or just trying your understanding of corporate banking, what are the different ways you can create charges on assets, because most of the corporate bank lending, when you do corporate banking for a commercial bank, most of the lending is secured. Okay, so whether you have fixed or a floating charge makes a difference. Right, one more point we can discuss is there's an expression that is used in the case. It's a CESTK trust. This is just nothing but a fancy French term for a beneficiary of a trust. Okay, so when you have a trust is created. There are certain important features of a trust. You have a settlor who is transferring the property to the trust. Okay, and the trust is to be managed by a trustee, and it is managed, the trust assets are managed by the trustee for the benefit of a beneficiary or a CESTK trust. That's all that it means. Okay, all right, so that covers our discussion of the Salomon case. We can